We are Group H, and in this video presentation, we are going to analyze the ExxonMobil Chemical Corporation case regarding the Hangman's News scandal. In March of 2023, ExxonMobil Chemical Corporation was sued by the U.S. Equal Employment Opportunity Commission for failing to take effective measures to prevent the display of Hangman News at its Baton Rouge complex. In January of 2020, a black employee of ExxonMobil chemical plant reported the discovery of a Hangman's News at his worksite. And in December of 2020, another news was found at the complex. Before that, 3 other news were reported at the site from 2016 to 2020. But although the company investigated the first case embedded to contractors, Exxon did not take remedial measures to prevent further racial harassment. According to EEOC, ExxonMobil had a legal obligation to take prompt action aimed at stopping the historically threatening symbols. Regarding this case, first we will analyze looking at New Jersey corporate law. The corporate law issues was the board of directors of ExxonMobil supposed to take effective measures to prevent racially hostile work environment that took place. Then after answering this question, we will propose internal corporate governance and New Jersey corporate law reforms to prevent similar challenges in the future.
To understand if the board of directors of ExxonMobil violated their fiduciary duties by not taking action to prevent the racially hostile work environment, we have to examine the director's duties in New Jersey law and then assess if taking measures to prevent a news hanging is part of those duties. In discussing the liability of directors, New Jersey statutes Title 14A states that directors shall, quote, act honestly and in good faith with a view to the best interests of the company and exercise the care, diligence, and skill that a reasonably prudent person would exercise in comparable circumstances. Also, the New Jersey Business Corporation Act imposes a standard duty of care on all directors, which attempts to prevent the existence of directors who are unaware of the activities within a corporation itself and ensures that directors act with a sense of responsibility and care in their fiduciary duties. The business judgment rule generally protects directors from being questioned on corporate affair conduct, essentially enabling the corporation and its directors to not have their business decisions interfered with, except for in situations of bad faith. However, this does not make directors immune to personal liability in breaching their fiduciary duties in New Jersey. The business judgment rule does not protect directors who abuse their discretion or fail to inform themselves of all material information readily available. And now we'll look at a case that tells us more about this. So in the case of Francis versus United Jersey Bank, Mrs. Pritchett, who was a director of the board of the United Jersey Bank, was ultimately proven liable under New Jersey law for her negligence, which was ruled to have ultimately led to significant financial loss of the bank, which she could have prevented had she been less negligent. So this case helps to teach us about the importance of negligence in directors' fiduciary duties, along with the business judgment rules application in New Jersey. And so also showing us how directors are essentially obligated to act with a degree of responsibility and care for the corporation. And so thus we can argue that the directors of ExxonMobil were negligent in not mandating that the officers of ExxonMobil implement stricter measures to ensure that their employees were protected from news hangings and, just as importantly, from repeated ones. However, because there's an absence of an official duty to monitor, it's hard to say whether there is a true breach of the duty to monitor a corporation. And now Barbara's going to go into a more detailed comparison between the existing duty to monitor in Delaware and the more ambiguous one in New Jersey case law, which will help to shape our potential reforms for New Jersey corporate law using Delaware as inspiration.
As stated by Patrick J. Ryan in the Business Lawyer Review, after post-war business expansion of the 1950s, when Delaware established its dominance among companies, New Jersey lost the predominance that it used to have during the early 20th centuries. Now, New Jersey courts do not have case volume that refined Delaware and New York judicial opinions into significant and dependable source of corporate law. Probably for that reason, in New Jersey case law, there is no explicit mention about directors' duty to supervise or oversee the corporation activities. There is no court decision that clarifies this understanding. just some discussions about negligence and direction to the care that Lucy already addressed. This duty of oversight, however, is developed in Delaware case law as a subsidiary element of the duty of loyalty that consists on an obligation to effectively monitor operations of the company preventing harm to the corporation, and is strongly correlated with good faith. Therefore, now we briefly compare New Jersey with Delaware law in order to understand what is the potential impact of this absence of the established duty to monitor standard might have on ExxonMobil case. In Delaware, most famous case about duty to monitor, the Ker-Mar International case, this duty of oversight is defined as duty to attempt in good faith to assure that a corporate information and reporting system exist. It consists mainly in an obligation to prevent harm to the corporation. Therefore, the board may breach its duty when harm occurs due to board's inattention or inaction. After Stone versus Ritter case, nevertheless, the plaintiff needed to prove that the directors acted in bad faith by showing similar and that the board was responsible for preventing the act since it was a wrongful or illegal act. According to some scholars, such as Vasey in Holland, the standard of the duty to monitor is a limited one, which is a quite high test, and what can be actually criticized, since it makes the claim hardly viable. However, the New Jersey law can still learn a few from Delaware judicial opinions, since liability claims from breach of fiduciary duties of oversight are even more limited, since there's no clear standard in New Jersey law about the duty to monitor itself. Looking at the ExxonMobil case, for example, we can see that if there was a clear duty to monitor standard in New Jersey law, the direction and action when it comes to take remedial measures to prevent racial harassment could potentially be considered a breach of the duty to oversight. After all the uses were wrongful and legal acts, violation of the Civil Acts of 1964, Title 7, they were repeatedly reported to the company by its employees. Therefore, they shouldn't have in turn a blind eye to this practice. The situation caused harm to the corporation in the form of loss of employee trust, damaged reputation, and litigation costs due to complaints filed by EEOC. Therefore, in New Jersey had more than clear fiduciary duty to monitor for its directors, it would be easier to resolve the ambiguity in this case. And with that in mind, now we are going to focus on internal corporate governance and some propositions to prevent similar challenges in the future.
Since the board of directors are responsible for acting and making decisions in the best interest of the company, how could they allow for a racially hostile environment? What underlying factors can this inaction be attributed to? One possible reason could be that the board composition lacked racial diversity, which impeded the board from being able to address the situation appropriately. Currently, ExxonMobil only has 2 non-white directors, with one of them being appointed recently as this year. This suggests that there may only have been one non-white director previously. Much of the research on board diversity has primarily focused on gender. However, in the light of the recent racial justice movements, the topic of racial justice has received increased attention within both the public as well as within the corporate law and governance. For example, since 2020, NASDAQ has established a comply or explain principle and disclosure of board diversity. The regulatory changes are partly motivated by the fact that more diverse boards also can address societal concerns of equity, inclusion, and social justice. Brummer and Strand have also highlighted the importance of diversity, equity, and inclusivity in relation to the work of board of directors. The authors explained that homogeneous boards suffer from so-called groupthink. Based on this principle, there's a tendency for a group of like-minded people to simply agree with each other rather than allowing for divergent opinions. Diversity has been proposed as an antidote to groupthink. Diversity promotes the introduction of competing ideas, values, and perspectives. Accordingly, it can lead to more communication and consideration of alternative courses of action. As such, a more diverse board is presumed to yield higher quality decision-making processes and appropriately handle red flags, such as the one in the ExxonMobil case. Cases of racially hostile work environments are unfortunately not unique to ExxonMobil. During 2019, the EEOC reported 23,976 lawsuits on the basis of race. It is also noted that the average employment lawsuit costs a company $200,000, hence failing to uphold civil rights to still happen at many workplaces and corporations are bearing the cost for these incidents. According to Blumenstein, the concept of promoting the best interests of the company encompasses making efforts to safeguard that corporations comply with civil rights and anti-discrimination laws. Ensuring that the company respects the employees' civil rights helps avoid reputational harm, legal disputes, and other consequences related to being perceived as a business lacking commitment to treating people with respect. Although the changes in external regulation help with pushing for a change, Blumenstein asserts that external regulation have its limitations. For example, they fall short of fulfilling their objective unless the leaders of corporation embrace values of respect and inclusivity. Hence, the composition of the board of directors and the recruitment of board of directors are pivotal. An HBR study showcased that the recruitment of board members is largely based on the present board's social network. The study also found that having only one diverse board member is not enough to reap the benefits of a diversity because they often feel undermined or treated differently. However, on a more positive note, a more racially diverse board is more likely to recruit more racial minority candidates.
Based on the facts and the issue they raised, we came up with 3 reform proposals that we think would improve New Jersey case law and prevent other cases like this one from happening. First, we wanted to find provisions to add to the New Jersey case law that would make it impossible or at least harder for such cases to ever happen. One solution to that is reinforcing the rules regarding the diversity of board members. The rationale behind this idea is that a more diverse board will be more concerned and alert about racial harassment and less likely to turn a blind eye to it. Section 14A61 of New Jersey Business Corporation Act only provides succinct rules about the composition of the board, and they do not include nor mention diversity. Therefore, our first reform proposal is to densify those rules and specifically add a section that makes it compulsory to have at least a certain percentage of board members that come from marginalized groups. That percentage would increase as the number of board members does to ensure that the reform is efficient. Also, this new section should include the sanctions that would be applied in case of non-compliance. New Jersey is not foreign to this thinking, as in 2020, New Jersey Bill A1465 was introduced to the state legislature and was basically meant to implement the same rules as our proposal. However, that bill has not been passed into law and was not meant to be included into the New Jersey case law, so this proposal is still relevant. We are aware that in spite of all the provisions of the law, incidents like the one we're studying will happen, which is why we have to propose reforms that set out the consequences of these breaches. The first step of doing that is adding provisions that clarify the outline of the duty to monitor. As we explained earlier, the New Jersey corporate law is too blurry when it comes to the scope of fiduciary duties, especially the duty to monitor, and this prevents us from stating whether or not this duty was breached in our case. However, that is crucial that as it will determine what the consequences of the faulty directors will be. So our second proposal would be to clarify the scope of this duty and to make it more like it is in Delaware. Indeed, the state is known for its clear body of corporate law, and New Jersey would gain to inspire itself from that. This clarification would make corporate governance easier and more fluid. Finally, still in order to make corporate governance more fluid and transparent, our third proposal is meant to facilitate internal whistleblower reporting. To do so, New Jersey case law should make it compulsory for the directors to make sure that corporations do offer the possibility for all employees to report any case of harassment. This obligation for the directors would be covered by the duty to monitor, whose scope would have been clarified by the previous proposal. This way, it would be impossible for the directors not to be aware of the harassment that's going on, and the lack of reaction could only mean that they chose not to react. The guilt of the directors of ExxonMobil Chemical Corporation would not be unsure had this rule existed. All in all, these reforms proposals are meant to ensure that such cases won't happen again. They aim at making corporations more aware and active about the issue to prevent neglecting directors from being able to defend themselves by stating that they weren't aware of the harassment going on. Thank you for listening.